Good afternoon. I've got 2 o'clock, so we're going to go ahead and get the webinar started. I want to thank everyone for joining us. If you haven't done so already, if you could please mute your phone. I've tried to do a global mute on everyone except for the presenter, of course, but it also helps if you mute it on your end just in case our system isn't catching your line for some reason, because we want to try to keep the background noise down while the presenter is speaking. There is a chat pod available, lower left-hand corner. Feel free to type in any questions you have there. We will open the phone lines up for questions at the end of the presentation. Without further ado, I'm going to go ahead and introduce Aisha Powell, who's with our Chief Legal Section and the Division of Diversity and Inclusion. Did I get that right, Aisha?
Yeah.
Okay, thanks. I'll just go ahead and turn things over to you. And you're kind of faint, so.
Okay, can you hear me better now?
I can hear you better.
Okay.
All right.
Good afternoon, everybody. Hopefully you received a link to the survey, and we did want to provide some additional information to assist you in responding to the survey. So that is why we are doing the webinar today. So just quickly, the survey concerns Title VI of the Civil Rights Act of 1964, which just basically says that no person in the United States shall be, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be otherwise subjected to discrimination under any program or activity receiving federal financial assistance. So basically, as recipients of federal funds, we have to assure that we are not discriminating in how we carry out our business. Some of the other non-discrimination laws that apply are Section 504 of the Rehabilitation Act of 1973, which basically applies non-discrimination requirements to persons with disabilities. It's also been extended to sex or gender, and also to age. We also have a couple of executive orders that apply, one on environmental justice, which applies to minority and low-income status, and then one on limited English proficiency, which basically requires us to provide meaningful access to persons who do not speak English as their primary language. So the purpose of these laws is basically to ensure that public funds are not spent in a way that encourages, subsidizes, or results in discrimination. And we can't intentionally discriminate against anybody. We can't purposefully treat them differently, but we also need to be cognizant of unintentional discrimination, something that we do that is neutral but ends up having an impact on certain communities that perhaps we didn't intend. So we want to make sure that we eliminate barriers and conditions that prevent underserved populations from receiving access, participation, and benefits from federally assisted programs, services, and activities. So how these laws apply to us is through Title 49 of the Code of Federal Regulations, Part 21. It basically applies Title VI of the Civil Rights Act to activities receiving federal funds through the U.S. Department of Transportation. And then Title 23 of the Code of Federal Regulations, Part 200, basically provides all of the guidelines that anybody who receives money through the Federal Highway Administration is required to do as it relates to non-discrimination. One of those requirements is sub-recipient monitoring. So when ODOT receives federal funding from the Federal Highway Administration, and then we pass on those funds to a local public agency, We have a requirement at ODOT to monitor a local public agency or a metropolitan planning organization that receives federal funds through us. So that is one of the reasons that we sent out the survey, is a way basically to review the status of our LPAs, our MPOs, our TPOs, and we also did a survey for our transit grantees. Just a way to review the status of your Title VI programs. And we want to use the information that we get from the survey to help us provide technical assistance to all of the subrecipients of federal funds, all the organizations that get federal money through ODOT to administer programs. We want to make sure that we are in a position to assist you in meeting your non-discrimination requirements. And at ODOT, we want to make it clear that we are not using the information that we're gathering through the survey to make any sort of non-compliance findings or affect any agency's eligibility to receive federal funds through ODOT. We are basically just trying to make sure that we have an idea of what you're doing and how we can assist you so that we're all meeting our non-discrimination requirements as recipients of federal funds. So as it pertains to being able to respond to the questions in the questionnaire or on the survey that was sent out, one of the key pieces of being able to respond is to have a Title VI plan, to develop a plan that identifies the steps you're taking to ensure your compliance with Title VI. And the pieces that should be in that plan we'll talk about under the next slides that talk about program guidelines. But basically, the questionnaire is just a way to review your implementation of Title VI program guidelines. And so when it comes to program guidelines, the types of information that would be contained in a Title VI plan would be first and foremost a Title VI non-discrimination policy, which basically is a policy statement. It would be signed by the head of your agency that just says that you're committed to non-discrimination in the programs and activities that you administer. There's also a requirement to have Title VI assurances, which is just basically an assurance that you are affirming that you're compliant with non-discrimination requirements and that you include non-discrimination language in your bidding documents, in your contracts, and in applicable real estate instruments. Another part of having a Title VI program or plan would be to designate somebody on your staff to be the Title VI coordinator, somebody who's responsible for initiating and monitoring Title VI activities. That would be the person that would be preparing any reports. That would be somebody who would be perhaps the liaison with ODOT as it related to Title VI information. Whoever's filling out the survey for your agency might be that person. Another thing you would want to consider is Title VI training, making sure that your employees receive Title VI training or non-discrimination training so that everybody at the agency kind of understands what their responsibilities are, to make sure that you're delivering your projects and services in a non-discriminatory way. So training can be provided through a means like this, where ODOT is providing training through a webinar or live in-person training. It can be other agencies, FHWA does some trainings as well, or if you have a Title VI coordinator, that person can also provide training to staff. There's a lot of ways to address that component. Another thing that we're required to provide is a notice to the public that basically informs them of their rights under Title VI. And typically, a Title VI notice to the public would contain 4 components. One component would be just a brief statement of non-discrimination that just basically says that the agency does not discriminate based on race, color, national origin. The notice should provide information on how to file a complaint with the agency if somebody did believe that they were being subjected to discrimination. It would also include contact information for somebody if somebody had questions or concerns. It would have information for who the person is they could reach out to with those. And it would also contain information on how to obtain information in a language other than English. And that could be just a brief one-sentence statement that says for information in a language other than English, contact, and then give a contact information. Our recommendation would be to have that statement translated into at least, the languages that are most frequently encountered by your organization, or at least the top language encountered by your organization, if any, so that a non-English speaker could actually read it. So another program guideline is to have a complaint procedure. And basically that would consist of having a complaint form, a form that somebody interacting with your agency could fill out if they had concerns that they were being discriminated against based on their race, color, national origin, or disability. So it would, and we sent out an initial email introducing that we were going to be sending out a survey, and attached to that email was a program guide for Title VI, and it included a sample complaint form that you can use for your LPA if you need an example of a complaint form. And then we also have a requirement to track Title VI complaints, investigations, and lawsuits, so that we have an idea of what kind of complaints we're getting, if we were able to resolve them informally, if we were able to address the concerns of the constituent, or if those were elevated, and what steps we took to address those. And we want to make sure that we have a log of those in case any issues arise. For example, if ODOT were to ask, you would have that information to provide to us. If Federal Highway were to come in and ask, you would have that information to provide to them. And, worst case scenario, if there ever were a lawsuit or something like that, you would have information that shows that you're proactive in making sure that any time a complaint comes to you, that you're taking steps to address the concerns of the constituent. We have been provided information by Federal Highway that their expectation is that we do not investigate ourselves. Certainly, if you become aware of an issue that can be resolved informally, where you can address the concerns of a constituent, by all means, Federal Highway definitely wants us to do that. ODOT would want you to do that, to make sure that we're addressing concerns that constituents have when they come to us. But if somebody were to file a formal complaint, typically that would get elevated up to ODOT to process, for the LPA, so that we could figure out what was going on and address it, and we might have some recommendations for you to implement or forward it up to Federal Highway if that needed to occur. So some things to include in a complaint procedure would be information about filing deadlines. So anybody who files a complaint with the agency, they have 180 days from the last instance of alleged discrimination to file a complaint. Complaints should be submitted in writing and signed by the person who's complaining. And we do accept complaints made verbally. Typically what we do is, in the event that someone were to call and make a complaint, we do need that eventually written down. So somebody could call in a complaint, but we would need to write down what their complaint was, and we would need to have them sign that so that we could move forward with an investigation. So we don't turn anybody away if they were to call with a complaint, but we do eventually need to get that complaint in writing and signed by the complainant. And some of the things that we expect to have in a complaint would be contact information, so that we could follow up with the complainant if we have questions or need additional details about what they allege occurred. We want to know what the basis of their complaint is. Obviously, for it to be a Title VI complaint, for it to be a discrimination complaint, the basis of the complaint has to be, that they were discriminated against based on their race or their color or national origin. The other non-discrimination authorities that I mentioned at the beginning of the presentation, if they say it's a disability, ODOT tends to accept all of those under our Title VI non-discrimination program, but we process the ADA complaints a little bit differently. But, again, somebody would need to tell us what the specific basis was of the complaint so we know that it actually does fall under Title VI or the Americans with Disabilities Act, or whatever the case may be. We need to know who the person is saying allegedly discriminated against them, so that we can follow up with that agency and see what occurred from their perspective. We have had a couple of instances occur where a constituent did file a complaint against a municipality, and typically what we find is that the municipality did not do anything discriminatory. There was just a lack of communication, between the city or the county and the constituent, and so those things were typically easily resolved. So it helps us to know, what agency we're talking about, so that we can, talk to you and figure out what's going on and how we can serve the constituent. We also need to know the dates when the alleged discrimination occurred. Again, the person has 180 days to file, so we do need to know those dates and that they're within that 180 days, and that again also helps with doing an investigation and figuring out what occurred and how we can remedy it. And lastly, we would need an explanation of what happened. As much information as the complainant can provide, again, so that we can have an idea of what occurred and maybe what we can do to address the concern. One other thing that is typically looked for when you have a Title VI program is data collection, analysis, and reporting. So it's good to have procedures for collecting data and analyzing demographic data on people that participate in the programs and services that you provide or anybody that benefits from those, citizens that are impacted by projects, or communities that are affected by projects. If you have a demographic profile, that helps with planning, that helps with, if you do any environmental justice, that kind of stuff can help if you're doing public involvement, having that information so that you know who's being impacted by a particular project or some other service or activity. And then, you can analyze that to see if there are any adverse impacts to any particular community, and maybe some steps that need to be taken to address potential adverse impacts. So another component, as I mentioned in the beginning, is the executive order on limited English proficiency and the requirement to provide meaningful access and language assistance. So basically, as recipients of federal funds, we are required to take reasonable steps to make sure that anyone who has a limited ability to read, speak, write, or understand English still has meaningful access to programs, services, and information that we provide. So the best way to proceed in determining what type of language assistance you would need to provide is to conduct a needs assessment and figure out the best way to provide information in languages other than English. One of the steps is to do a 4-factor analysis. I'll provide more information about what that is in a moment. Consider the safe harbor provision, and then identify vital documents. So what is a 4-factor analysis? Basically, the 4-factor analysis is the first step would be to determine the number of limited English proficient persons that are in your service area, and that are likely to be encountered. If your service area is your city or your town or your county or the state of Ohio, you can typically pull census data, or if there's other means of obtaining a demographic profile of your region, and get an idea of how many people are in your area that speak English less than very well. And when you have an idea of how many people speak English less than very well, and what languages those persons speak, the next step would be to assess your frequency of contact with those individuals. Are those individuals, coming into your agencies for services? And if so, how frequently are they coming in? And then the third step would be to consider, the nature and importance of those programs and services. If it's food assistance, if it's, educational assistance or job readiness, construction projects, the importance of those persons having access to information about those services. And then you have to consider your resources. Obviously, translating documents, providing interpreters is a cost to the agency. So you're going to want to consider, what would be the cost of providing information and documents, and what would be the cost of providing those in other languages. And then figure out kind of the best way to provide language assistance. One of the guides that the Department of Justice puts out is the safe harbor provision. It basically identifies a threshold for determining whether or not a document should be translated into a language other than English. And the threshold is basically 1,000 persons, or 5% of the total population that's likely to be affected. And this safe harbor provision, it only applies to the translation of written documents. It doesn't apply to providing meaningful access through verbal language services and interpretation services. So this is the kind of thing that you would look at and determine, if there's if you have a project and it's running through a Hispanic community, you may want to consider having brochures printed, or your public involvement materials and brochures printed in English and Spanish. You may want to consider having a Spanish language interpreter at a public involvement meeting. So those are some of the things that you would consider to provide language assistance. As it pertains to identifying vital documents, a vital document would be anything that's critical for ensuring meaningful access to major activities and programs. So whether a document is vital could depend on the importance of the program, what would be the consequence to the limited English proficient person if they don't have that information. And those are the types of documents that you would want to consider translating in languages other than English. And again, you can identify which languages you're most likely to encounter, what types of information are vital to get to members of the public, which things you might want to consider proactively translating into a language other than English. And you may determine that you have rare, if any, interaction with limited English proficient persons, and you may determine that it's most cost effective to provide language services on an as-needed basis, and that's perfectly acceptable. Again, I think the key here is that you're assessing what the needs are of the community, the constituents that you're going to encounter, and making sure that you have a way to give them access to information that they need to interact with your agency and be part of your programs and services. Another area, and we've talked about it a little bit already, is public involvement. It's always good to have a public participation plan. I know a lot of agencies already do have public participation plans, but this is an important part of a Title VI program as well. That you have a public participation plan or public involvement plan, and that included in that is a description of how minority communities, low-income communities, and limited English proficient populations are included in planning processes. Your public involvement plan would also describe the steps that are taken to ensure that events are held in accessible locations, things that places that are geographically accessible, structurally accessible to persons that may have mobility issues, having public involvement meetings on a transit line, having public involvement meetings on days of the week and times of day where you're actually going to be able to reach the communities that are going to be affected by a project. And then public involvement plan can also describe the process for providing information in alternative formats, such as sign language or Braille, if that is needed to help serve the community that's being affected by the project. So that is the basics of what is needed to have a Title VI plan or Title VI program. That's the kind of information that ODOT is going to be interested in learning through the survey, what you're currently doing, what we can help you do to make sure that you're compliant with non-discrimination requirements, and that ODOT in its monitoring requirement is also compliant with non-discrimination requirements. So resources, you're welcome obviously to visit ODOT's Title VI webpage. We put our Title VI plan on our webpage, as well as some of our other reports, our policy, our complaint form, so you can see what we have out there. Our Title VI plan is extensive. It's lengthy. You certainly wouldn't have to have something that's quite as long. Most of the Title VI plans that I've seen that are more at the regional or local level are maybe, I think our plans around 60 to 70 pages, but local plans we tend to see things that are more around 20 pages. And they kind of, again, just outline what you're already doing and provide examples of complaint forms and your complaint procedure and things like that. FHWA also has a Title VI web page that you can visit and get a better idea of what their requirements are of recipients of federal funding. And then the U.S. Department of Justice has a limited English proficient website that provides information on LEP populations and data and different things that can be used to assist with looking at language assistance. So I think we can open it up for questions.
Sounds good. I'll go ahead and unmute everybody. All right, you're all unmuted now. At least on my end. If you've muted your phone line, you'll have to go ahead and unmute on your end. And I'll go through individually and unmute the phone lines too. So if you have questions, please feel free to go ahead and ask Aisha. Are there questions for Aisha? Well, we're not hearing any questions. You did a really thorough job on this presentation, Aisha. We really appreciate it. And I did attempt to record the presentation, so as long as that's successful, I'll be sending a link out to everyone who was on the webinar today. And then I will also attempt to email out to everyone who actually received the survey as well. So one last chance if you have any questions for Aisha.
Are you going to mail or send the presentation?
Yeah, I can send. Is that okay, Aisha, if I send the presentation out too?
Yeah, sure.
Okay, great. Yep, I'll
Thank
send
you.
a copy of the presentation out. Are there any other questions? Okay. If not, thank you for joining us this afternoon. We appreciate everybody's time and attention. And if you have any questions as you're completing that survey, Aisha will be available. You can always give her a call.
Yes.
Thank you, everyone.
Thank you.